and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting is a Melbourne solicitor, and I celebrate him every time as the longest-running broadcaster on what was 3LO and then was ABC 774 ABC Radio Melbourne, and is now ABC Radio Melbourne. David Whiting, welcome. Good morning.
Thank you, Raph.
You had
It's been a while. I did. I had homework from Jennifer from Hampton, and her husband, who was a tradie, and he'd gone to a work information session, and he was told that you can't use your mobile phone if it's on a charging pad, and we have lots and lots of cars that now come with charging pads, so you don't have to plug your phone in to make it to charge it. And she's right. You can't use a phone while it's on a charging pad because it needs to be, in order for you to use it on any basis whatsoever, it needs to be secured in a mounting affixed to the vehicle while being so used. So you have a vehicle to which you affix a mounting pad, and then it needs to be secured to the mounting unit.
But is it illegal to have it on the charging pad if you're not using it?
No. That's okay.
Legal.
That's legal, yes.
Right. So that's just like having a box of tissues on the dashboard.
Yes, but can I say, you've then got to see what on earth is use, but you can't use it, can't touch it if it's on a charging pad, but you can touch it if it's in a cradle.
Are you clear on what use is? Because that's quite severely prescribed as well,
that's absolutely. There's about 8 or 9 elements to the to
I think
use.
it's only changing the music and navigation.
There's it's a question of whether you're putting something, whether you can, because if you can talk to it, it's much better than if you have to touch it.
Of course.
And yes.
Of course.
So, but touching it is using it, so be careful.
And it talks back now.
It does.
The joy of being the augmented human. We are all cyborgs now. It's just the cyborg bits are on the outside of our bodies instead of the inside. David Whiting doesn't need to be a cyborg, though. He doesn't Google the answers, by the way, just in case you were wondering. It's all up there in that amazing mass of brain cells. Grant, you're first off calling from Wattle Glen. What did you want to mention?
Hi, Raph. Hi, David. I'm trying to negotiate a disability access issue on behalf of my mother with a body corp. She needs to do a very small modification to her steps to get easier access with her walking frame in and out, and a very simple handrail put on. The body corp manager is telling me that Mum has to pay a $440 fee for a ballot, of which there is no guarantee that she'll get an approval. And I just thought that's ridiculous. I mean, this shouldn't even be an issue when a person with a walking frame with an assessment done by an OT through her
let's separate the need. Right? Let's accept the need. The question is this going to require an alteration to the common property? And if it does, then you require consent or approval. But Grant, I'm happy to take it on notice and see whether it's something that the committee has to do. So what's the scope of works? Build a handrail? And what's the rest of it?
Handrail and a layer of bricks to make the depth of the step slightly
less
broad. Yeah, so she has the ability to stand on the step with her walking frame. So we're talking maybe 20
so you're extending the step, as it were.
Yes,
understand.
Exactly.
Okay.
Yeah.
So it's just moving it from a step to a platform for a better description.
Correct.
Okay,
yeah.
Grant, let you know next week whether I think it's, and I take it all of the work is on common property.
It's on common property. It's
yes.
at no expense to the body corp.
No. Its question would be if it's really a question of whether or not it requires the consent of, whether it requires a consent at a general meeting or whether it can be dealt with by the committee.
He'll take that one on notice, Grant. That's a good one. I'm sure a lot of people will end up bumping into something like that, so thank you. Let's go to Jace here in Cheltenham. What do you want to mention, Jace? What's the query?
Good morning, thank you. I was sued at VCAT by my ex-landlord. That was dismissed, but I had a claim to get my bond back, and that was ordered to be enforced by the landlord.
Was your bond no longer at the bond authority?
This is a commercial tenancy.
Okay, yes.
And So he has been ordered to repay my bond, and he's not done that. So I did email him to confirm my bank details, and I did receive a part payment, which was approximately 10% of what he owes me.
Wow.
But we've had nothing more coming since then. My question is, what do I need to do to enforce the order? Do I go back to VCAT?
You get a certificate from VCAT that you take to the Magistrates Court, and the Magistrates Court will record it as a judgment there, and then the process is available to the Sheriff will be available to you.
Do I have to get a lawyer to help me with this?
You shouldn't need any assistance to achieve those two steps. Have a look at the Magistrates Court website, magistratescourt.vic.gov.au. They'll give you, as will the VCAT site, they'll give you the process for moving a judgment from VCAT to the Magistrates Court, and then go to the Magistrates Court site for the documentation you'll need to enforce the order at the Magistrates Court. It will then be referred to the Sheriff for enforcement.
Okay. And in terms of claiming for the cost of doing this, can that be awarded?
You'll get no money for your labour, but where there are fees involved, they will be added to the claim.
Okay. All right. And is it a long process?
The slowest part will be the enforcement process at the Sheriff's. And I'm not promising that will be quick because, are you owed the money by a company or an individual? So is it XYZ Proprietary Limited or is it John Smith?
An individual trading as a company.
No, that doesn't happen, right? Be like me trading as you. They're two separate legal persons. So if the landlord on your lease was XYZ Proprietary Limited, this is a process which is going to fail because we'll never be able to find any asset that belongs to the company other than your... How much does he owe you?
About $4,000, a bit over $4,000.
Okay, it's not enough to wind up the landlord. It really depends on how pig-headed you both are. It's theoretically possible to move the judgment in 2 jumps to the Supreme Court and apply for an order that the place that you rented be sold, but you don't have enough to do a winding up application because at $4,000 it's not over the threshold. So your difficulty would be XYZ Proprietary Limited. I wouldn't bother with the Sheriff. What you might consider doing is you move the judgment to the Magistrates Court, then issue what's called a summons for oral examination, where the director gets directed to come to the Magistrates Court to explain what assets the company's got. Mm-hmm. Right? And the irritation of getting a summons, and if they don't turn up, you can ask for an arrest warrant to be issued by the Magistrates Court. Right. So you just have to get just a bit narky, but you'll get there, Jace.
Okay.
Good
luck.
Thank you.
Thanks, Jace. Good luck with that. What are the VCAT wait times now these days? Someone wants to know. Do you know?
18 months is a. It's a resource and a backlog.
18 months.
Look, they have a series of lists at VCAT.
Yeah, sure.
But what they try and deal with are priorities. So residential tenancies are a priority and guardianship is a priority because they affect the day-to-day life of individuals as opposed to civil claims, which are essentially a debt recovery process of some form. So averages is kind of a meaningless average. You need an average by list, and I don't have that.
No, interesting though. Good rough figure. That's okay. Rule of thumb or something like it. Thank you, Jace. Good luck. Betty, you are calling from Brunswick East. What's your question? Betty, you there? Oh, Betty's not there. Tell you what. Oh, yeah, go for it, Betty. You're on air.
Yes. My question is about divorce. I got married in Argentina many years ago. Divorced in here, Victoria, 20 years ago. Recently, I learned that I'm still married in Argentina. So
is that because is there civil divorce in Argentina, or was there 20 years ago, or was it just church divorce?
Yeah, no. It's civil divorce, yes.
Okay.
Yeah.
The law in Australia is that you have the standing to get divorced based on the fact that you live here.
Okay.
All right. Now there are some countries, and at one stage the Switzerland I think was in this category, or the Philippines, for example, where divorce is incredibly difficult, if not impossible. So what you could do is you could race off to Vegas and get a divorce, but still be considered to be married in another country. So the answer would be, in accordance with Australian law, Betty, you're divorced. What you've got, though, is that the law in Argentina doesn't recognise it.
Okay.
So what I can say is you could remarry in Australia, but if you wanted to get married in Argentina, you'd be guilty of bigamy.
All right. Okay. What about properties in here? Because obviously, since 20 years ago, I just bought a property and I got some sort of assets. So, is that?
Did you do where? Sorry, where is your husband/ex-husband?
Well, he was until not long ago. He was in Buenos Aires. Now he moved to Australia, but he asked me for my signature for him to sell a property that he bought in Argentina.
Yes.
After we were divorced.
Yep.
So, because that is where I learned that I'm not divorced over there, that he needs my signature for him to be able to buy something that I had nothing to do with.
Yes. So where's the problem?
The problem is no, it's all right. I'm going to give him the signature that he's asking. The problem is that with me about my properties in here.
I'm not in the slightest bit worried, Betty.
Yeah.
All right. Now he could go back to Argentina and apply for a divorce and a property settlement. I really wouldn't worry about it. I just don't see it going to happen. And what you would do is you would seek a stay, a permanent stay on the enforcement of the order if he was to make the application.
Good luck, Betty.
Or a will in favour of my daughters and all the rest.
That will stand.
I think David's saying to you, Betty, that your concerns. You don't need to have concerns.
No, the risk is so low, and now the husband/ex-husband is living in Australia.
Yeah. Thank you, Betty. I'll get to more calls. I just wanted to read this one from Rick in Baldwin. This text is headlined "The Power of David Whiting," which is a good name for a book, but let me read the text. For 4 weeks, my local council, Burundara, refused to provide the name and postal address of my absentee neighbour so I could commence fencing replacement process. Only when I flagged that this intransigence would be aired before David Whiting on 774 for opinion next day did the council cooperate. Pronto. Hail David Whiting. That is from Rick in Baldwin. Any need to add to that?
No.
No?
No. Flattered.
Fan mail. Ali is in Hampton. Ali, what's your query?
Oh, good morning, and thanks for taking my call. I live on a corner property, and we are surrounded by 5 ichibom trees, otherwise known as Norfolk Island hibiscus, and they drop these fibres that are very sort of highly irritant to the skin and very painful. And it means that when we're outside for a number of months in the year, it's just it's almost just too uncomfortable to be outside.
I take it the trees are on council property or neighbours' property?
Correct. Council property on the nature strip.
Mm-hmm.
Do we have any... So Bayside Council have refused to remove them. They say we have to show that we're highly allergenic to it. So do we have a case against council because it's basically preventing, quiet enjoyment of our property?
My line would be, I would have thought that the fibres would be silent, but let's not, that's a bit callous. Ali, I would be suggesting that you might, but there is a piece of legislation called the Road Management Act, and it limits the responsibility of road-making authorities and road management authorities in lots of circumstances. And the legislation came into being when somebody tripped on a running track on a route from a tree, and the question was, what are the maintenance obligations of road-making authorities? So I'll take that one on notice too, as to whether or not... the other issue is that you might raise it with the Ombudsman, but let's talk about the obligation next week.
Okay, thank you very much.
Thank you.
It's good. He likes having homework, Ali. He gets bored, doesn't like watching television in the evenings. He much prefers homework. His family like him when he totters off to the law library. Sam is in Ocean Grove. Sam, what's your query?
Hi, David and Raph. just a general one, David. I've unfortunately been informed last night that I'm a victim of one of these latest highly publicised data breaches. Just wondering, from a legal point of view, should I be being prudent by sort of thinking I might have to engage a lawyer down the track if anything untoward happens with my identity?
Well, the first thing I would be doing would be securing your identity before I was looking at allocating blame and seeking damages. It may well be that you have an action for damages, but would you put the effort into protecting your identity?
Oh, no, certainly, David, yeah. But my concern more is that, so the company's listed a whole lot of steps, which I'll obviously go through, but I'm more concerned about if I become liable for debts and that type of thing down the track more than damages. I'm more concerned if my identity is used to procure anything and then I become liable for it. Is that a thing?
Yes, it is a thing. The answer is somebody, if they've got your identity, they could use it to create a liability that you would then need to deal with. But that's the price we have for living in an electronic age.
Is there anything a lawyer could do to help prepare?
But there is a website where they, which is funded by the banks, which assist people in fixing their identity.
Yeah. Right. There you go, Sam.
No worries. Thanks, guys.
Good luck with the data breach as well. 1300 222 774 is the phone number that Rick has called from Emerald. What did you want to raise, Rick?
David, good morning. I'm just interested. We're thinking of acquiring a unit and using it as Airbnb, but I'm told the body corporate frowns upon it and doesn't really want you to do it. I want to know what authorities do the body corporate have in overriding the will of the local owner?
There are some provisions in the Owners Corporation Act relating to that relating to the use of short-term tenancies in residential properties. I don't think they work as well as an owners corporation would want them to, but have a look in the Owners Corporation Act and the Owners Corporation regulations and see whether you can make it work. Also look at the council bylaws, because there's certainly a proposal that councils want to be able to restrict the number of days that property that they would normally consider as permanent accommodation is used for temporary accommodation. So look at the council's view and then look at the Owners Corporation Act and regulations.
That's very helpful. Thank you very much.
Good luck, Rick. David, just to follow up, most of the time the body corp can't stop you using it as an air. At least we get a
changes made to the legislation so that they're able to deal with a noise and harassment and that kind of thing. So particularly it became an issue down in the Docklands area with lots of short term. So there is some stuff.
But that is about the problems the guests might cause. Am I right? The body corp technically can't stop you.
I don't believe
with
they
a short-term lease.
No.
At least that we get a lot of calls with people saying that's the problem they face with their neighbours renting out the one next door as an Airbnb. 1300 222 774 is the number. Ivan, you're in Brighton. What do you want to mention?
Yes. Good morning, David and Raph. We rent commercial premises, which is a shop. We have a standard Law Institute lease. The owner has insured the glass as per the lease. There was a glass breakage from an unknown source. The agent is trying to say that we have to pay the $500 excess. Nowhere in the lease.
No, not the way you've described it, no. I mean, most leases that I see, the tenant's responsible for the insurance. But if you've got a lease, so in a sense, they're then responsible for the plate glass. But if the plate glass is an obligation to insure for the landlord, then you fulfilled your obligations in relation to the glass by paying the insurance premium or it being built into the lease.
Right. So they're standing by wanting the $500 paid for by ourselves. And as I said, it doesn't say that we have to do that by the lease. What can we do about that?
So you will just refuse to pay.
Okay. What if there been an earthquake and the excess, I believe, is $20,000 under a...
Well, I understand the principle's the same. The question is whether or not you've got the obligation to pay the insurance. Now, it might be possible for them to get insurance that made the excess $5 instead of $500.
Yep.
So I'm saying
We
they're
do
the
have
one
to-
who've chosen the insurance.
Yeah, correct. I'm with you 100% sure.
Good luck. Stand firm.
Thank you.
Just ring
Thank you
Burundara
very
Council. Yep.
Stand firm, Ivan. 1300 222 774 is the phone number. Jane's in Balan. Jane, what do you want to say?
Jane, it's me.
Yes.
And I'm asking a question. I've been executive for 30 years, and the will could not be executed until my brother died in a house that had to be sold.
Yes.
And in the meantime, the other executor has passed away some 15 years ago. And I'm just wondering about, it sounds awful, but the executor fees, what happens with that?
What does the
other
will
part?
say about paying an executor?
Well, there is no payment.
Right, then
It doesn't allow for
the
that.
only basis upon which there are three ways you can get paid as an executor. If
Yes,
the
I'm aware
will
of
says
that.
so, if the beneficiaries agree, or you go to court and ask.
Right. Yeah.
So the person who's died is not going to get an executorial fee, but you're able to ask your beneficiaries whether or not they will make a payment to you for acting as an executor.
Right. Yeah. Okay. Thank you very much. for
So
answering that.
what you do is you would make a submission to them about what you might seek to be paid and how it's to be calculated. Now, I don't know what work you've done as an executor, but as a general proposition, a private executor is unlikely to get more than 2 or 2.5% of the value of the assets in the estate, measured at the time of disposal. So if you're selling a property 30 years after the grant of probate, then there's going to be, I would have thought, an incredible increase in value over time.
It has. Yeah.
Right? So I'm capping it at 2 or 2.5 as the logical. You see, you may just simply come up and say a fee of X.
Yeah.
But if you don't get agreement, you make an application to the Supreme Court to fix your commission.
Okay.
Yeah. It has been significant amount of work for 30 years.
And that's what you tell them. You give them it's called a report as to your pains and troubles.
And you document
This is what
it?
I've done.
Document
Yes,
what the
if
work
you're
is?
making an application to court, it's on this day I did this, on this day I did this, on this day I did this. It's monstrous.
Each week I made a phone call for 5 years. Every week I called so-and-so to check on the property, something like that.
Yeah.
Yeah, it was significant. And is that a long time sort of process, David?
Jane, ask the beneficiaries first. And the answer would be, the issue will be putting together the bill.
Yes.
I would have thought your commission claim would be resolved in 6 months. But that wouldn't prevent you distributing most of the money. So sell the house, work out what your commission claim is, what the cost would be of running the claim in the courts, and distribute the balance is where I would be going, because otherwise you come to court and you say, well, I've got $1 million, but I'm not going to give anybody any money until they pay me the $20,000 I want for the work I've done, is not going to make you look good.
Good luck, Jane. Good luck with that. Final query to Ray. You're in Bendigo. What's the question, Ray?
Thanks for taking the call. I've got an issue with water coming into 2 rooms in my house from the adjoining property. I've established through council that the property doesn't have a drain on the boundary.
Ray, you have the ability to... Section 16.1 of the Water Act allows you a cause of action for unreasonable flow of water. And the expectation is that they're able to dispose of the water in their own property. So it's really where it's coming from at their property, whether they or a predecessor in title has done anything to make the water worse. In which case, yes, you have a cause of action, which you run at VCAT, of all places.
Good luck, Ray. I appreciate that. David's got a fair bit of homework that he will bring back to us next week. Don't forget, David's here every Tuesday morning just after 10 o'clock. Thanks so much, David.
Thanks, Raph.
David Whiting, Melbourne solicitor.